Heyo, heyo, and welcome to this Monday afternoon in the United States. It's in the middle of the night in Europe, and it is already tomorrow in Australia and Japan, Korea, and stuff like that. Hi, everybody. And we are back to getting to know more about the young thug RICO-trial. There was a new hearing, I believe Thursday or Friday, about some evidentiary things that the defense wants excluded, and of course the prosecution wants in. So it will be interesting to see what that leads to. I believe it is about a laptop that was from a laptop from prison or something, a prison laptop of sorts. So that is what they are going to argue about. I thought that hearing wasn't supposed to go for until a couple of weeks, but here we are. Hi, Jackpot Springs and Unicorn and Troy and the rest of you. And for you over at Rumble, please make yourselves known in the chat over there as well. Yes, I am dual streaming here on YouTube and on Rumble. If you want the link to the Rumbles, I will have it for you in a second. Hold on here. Share, copy, there. So yes, I am building up a platform on Rumble as well, because YouTube doesn't like my coverage of serial killers. Seems it doesn't really matter if there's been coverage of serial killers for well over a decade on YouTube. They just don't like my coverage. Hello, Atheist Ant. Good to see you. Yes, I watched the first couple of minutes on Law and C-Word, and of course they forked it up. So they begin in the absolute middle of the prosecution telling the judge why it should be good. shall we start off with some of the YouTube things? You know, like, subscribe, all that thing. And if you're social media, don't be afraid to share the link to this stream on your social media. That would be very much appreciated. Very much appreciated. But here we are. Let's do that. And let's find the tractor there. Okay, so again, we are going to begin in the middle of the prosecution's argument.
But none of that information, neither the obtaining of the first search warrant, the execution of that first search warrant, or any evidence obtained from that first search warrant was included in any way in the application and the affidavit supporting the application for the second search warrant that was taken out on June 8th of 2023. That search warrant stands solely by itself. The affidavit does not mention a search warrant or any evidence obtained from any illegal search whatsoever. Mr. Hurd argues in his motion that this court should suppress the warrant because it is, quote, fruit of the poisonous tree. But I just do not believe that that's accurate, Judge. I have provided a case in there that essentially stands for the proposition that when a first illegal search warrant was obtained and then a subsequent second search warrant was obtained, the second search warrant is good, even if the first one was illegal, as long as no information obtained from the first search is included in the application or affidavit for the second one. And that's precisely what's occurred here. Judge, in this warrant, that warrant stands alone. It articulates probable cause that both Mr. Eppinger and Mr. Johnson violated 42-5-18 in possessing the telecommunications device. And so with that being said, Judge, that's my argument as it relates to the motion to suppress that was filed by Mr. Johnson. And if anything else is raised, I may have a brief rebuttal as to that.
Okay. Do you plan on calling any witness if necessary?
I have a witness here and available if necessary, based on the motion that was filed, Judge, and the allegations in the motion and the enumerations of error. I believe that this court could decide this entire issue on the four corners of the document, but Investigator McCormick is here and ready to be sworn and provide testimony if any is needed.
Okay.
Yeah, so this, what he calls is a legally obtained electronic device is a laptop. And I don't know what the defense will go for. I haven't watched that far. But just the fact that they first took it via one warrant, that was not good. So they did a second warrant for the exact same thing, now claiming, oh no, it's not fruit of the poisonous tree. We promise we found it by other means. Sure, kid, sure. But as I've heard in previous motions hearings, sometimes these things are allowed. So let's see what the defense says.
All right.
Your Honor. Good afternoon. I will object to that. I know when we were standing, the court said, I will object to that. The state is going to provide some testimony I'd like to hear before they get to hear the argument of Mr. Johnson. Otherwise, the four corners rule is in place.
I mean, I can consider it based on the four corners of the motion and the warrant that's been provided. And I'm inclined to do so. So at this point. All right. Anything else, sir?
Yes.
Yes, Mr. Hurd, go ahead.
Okay, thank you.
All right, Your Honor. Once again, Denoris Hurd on behalf of Mr. Eric Johnson, who is representing Mr. Christian Eppinger in this matter. And based upon information thus far, is there has not been any testimony independent of what has been enumerated in the response motion by the state. And furthermore, I will talk about a few of the points that were brought up, that was raised in our motion to suppress and motion to dismiss the warrant in here. I think The recitation of facts is somewhat similar, so no need to revisit that issue. However, there is some issues that we do definitely need to raise regarding, there's a few facts that we definitely need to be focused on. One of the facts that was very germane is that initially when this search warrant was issued and Mr. Johnson's laptop was confiscated, the state conceded that there was some information that was taken from that laptop. That was particularly taken from the laptop. And then once Mr.
What was taken? What was taken?
I don't know. He just said there was information that was taken from that laptop in order to, it had to be, because at that point in the second warrant, it talks about the idea that the Instagram pages or the handle of Mr. Eppinger, that was not common knowledge. So at some point, somebody had to grab that information from Mr. Johnson's laptop. And so thus, to say that there was no violation or in this matter, or there was no search is incorrect.
But wouldn't there be plain view if the law enforcement officers were walking behind Mr. Eppinger and Mr. Johnson and could see what was on the screen?
Well, Your Honor, I don't know that testimony. I have not heard that. So no one's testified to the fact there was plain view. There was nothing indicated in here in his motion.
States one that references that?
Yeah.
Yeah. So more or less what happened is more or less what happened is the laptop was firstly confiscated, and according to this defense attorney, something was taken from it. He doesn't know what, but it's referred to earlier that something was taken from it, which would make this second warrant also a fruit from the poisonous tree, because all of a sudden they found his Instagram posts, all of a sudden, by miracle. And now apparently a cop or something of that will testify, oh no, we walked behind him and saw it. It was in plain view. Yeah, I doubt it. But let's see what comes up.
Okay, I have a certified copy of the warrant, or as it is. Yeah, it's a certified copy of the warrant.
Yes.
It states one. And in the affidavit for search warrant, well, on February 23rd, there was one of the deputies that advised Mr. Eppinger he was actually using Instagram, told him to shut it off. So that's one instance. May 31st, investigator Moore witnessed Mr. Eppinger go to the Instagram laptop provided by Mr. Johnson. He advised Captain Moncrief of this incident.
Yes.
I mean, so these instances are fairly within the affidavit and four corners of this particular warrant.
Okay. Your Honor, but I understand what you're saying. However, first of all, there have not been any testimony to that. Secondly, is that
But can't I just consider what's in the warrant? Do I have to take any testimony?
well,
I mean, Mr. Steele asked me to consider testimony, but can't I just consider what's in the warrant if it's a certified copy of the warrant?
it is obviously whatever's in the court's discretion.
Okay, all right. I just want to make sure.
Yeah. Whatever's in the court's discretion.
On the same page.
That's applicable.
All right.
So yes. So all right. So we get to the point. We were talking about the idea of whether or not it was something regarding the ability for them to see. I don't think, now I'm an Instagram user. It does not show your information as an Instagram provider, even on a plain screen. There's nothing that shows the handles or anything like that, which has been enunciated and enumerated in this.
Well, it says in the warrant here, based on the observations by various members of the FAST team, this affiant was able to determine Mr. Epinger was using an Instagram user account name @_BigBriss1. And they were able to determine that that's his Instagram account. So, and that was just based on observation.
Yes.
This is one of them. You know about Melly. That trial was a mistrial and will continue later. This is the Young Thug, which is a RICO trial. So yeah, he's alleged to have been running a street gang and rapping about it of sorts. But so far, as I've heard so far, I've started covering this a few months ago, and I'm at day 4 of the Daubert hearing, which is a cluster F on itself. And so far, nobody alleges running street gang and rapping about it, but they do bring RICO charges so they can more or less, in a RICO charge, everybody is guilty of everything within that gang. So Atheist Dan says this warrant to search the kill leader box was crappy, but for that warrant for them same smells like roses. Yeah, no notice from YouTube. I heard somebody else who got noticed from YouTube. So yeah, it's YouTube as per usual. Some get, some don't. I wish I could do anything about it. I do post an hour before on Twitter and on my Discord and stuff like that. So follow me on Twitter, and then you can get notified there. It looks to me like this specific warrant, which is the warrant number 2, that all of a sudden they saw everything from plain view. Yeah.
That's part of the affidavit in this case.
Right, Your Honor, that may be part of the affidavit, but that part, that is untrue. You cannot see a person at, in this matter, at @big BRIS 1. You can't see that on their on your Instagram page. That doesn't show. So in order for them to get that information, they had to get inside that laptop in order to grab that information. So that cannot be seen in plain view at all.
Oops. That's kind of serious. He just claimed that the sworn affidavit from these people, that they was untruthful. They were untruthful. Oh, he needs to back this up with something. Because accusing somebody of lying is kind of a big deal.
So therefore, the information that was derived for this second warrant was based upon their searching under that first warrant. So there was not, and so bottom line is that first search warrant was void, and it was admitted to and conceded by the state. And for them to pull that information and use that information, they use that information from that first search warrant in order to create this second search warrant, Your Honor. And so thus, that is why we're talking about the argument as far as the fruit of the poisonous tree.
Have you been able to review Johnson versus State at 310 Georgia 685 2001? Follows the search of it's referenced in the state's brief, but it involves the search of a defendant's cell phone, and Johnson, similar like to your client, alleges that the phone was legally searched at a prior search warrant, and the subsequent obtaining of another search warrant, the resulting search violated his Fourth Amendment rights as evidenced obtained after the search warrant is through the poisonous tree. Kind of similar to your argument here, but our Supreme Court determined that the search warrant, the second one, was based on sufficient probable cause, and nothing in the affidavit references the information derived from the pre-warrant search. So in this case, Johnson's phone. So the trial court properly concluded the evidence pursuant to the warrant was not, as Johnson claims, through the poisonous tree. And they also cite Reeves versus the state, 284 Georgia, 181 pinpoint, 183 at 208. Search warrants were not tainted by earlier warrantless search because no information obtained during the warrant search was used to obtain the warrants. But in this case, you had a warrant. So
That sounds to me like cops knew it, they knew the statute, and were very careful in not admitting how they got the probable cause for the second warrant. In my opinion, I could be wrong, but it sounds like that to me.
but
Yes. Yes, Your Honor. Actually, we also want you to be mindful of the site of State versus Thurston.
spell that last name for me.
Thurston, Thur.
Thur. State v. Thurston. What's the
State v.
site?
Thurston. It's a May 30th, 2023 case. And
What's the site?
well, I have it here, the Lexus site, which is 2023 Georgia Appeals, Lexus, LEX.
Yeah, it looks like that. That's not a good thing. Be careful, kid.
XIS 230, and also have a Westlaw site of 2023 WL 371011.
Wes, did you get that?
What were the prosecuted, sir?
The Lexus, what's
WL.
okay, WL is 3710111.
Thank you.
Well, he came
And
prepared.
Your Honor, I do have a copy of the
Oh, that'd be wonderful. Do you have one for
May I approach?
do you have one for for opposing counsel as well? All right, thank you. That would be wonderful.
But if you have a May 2023 decision, that could be really interesting if that overrules the previous, or if it can do a workaround.
So, Your Honor, so
Let me take a look at the case so we can look. I found it and I'm looking at it right now because that certainly would be illustrative of this particular issue.
Yes, they are still doing jury selections parallel to the motions because this judge is fed up. Yeah. Oh. Here's the case.
Okay, I'm with you, Mr. Hurd. I've got it. Okay, but I think you need to distinguish these facts from Thurston's motion. Thurston's motion, they actually downloaded and extracted information out of the phone. And use that similar data in the second warrant.
well, that's completely what's analogous in this situation. I do want to go back again to the
What's different? I mean, you need to kind of tell me with
Okay.
particularity what it is that, is the same or similar information.
So the similar, just in that case that we're just talking about, Thurston case, it was a download, and they used that download information in order to obtain the second warrant. Okay, now that download information that was done in the first warrant was invalid, but they used that invalid information to obtain that second warrant. Very similar to this situation here, and
you could hear it more or less between the lines in their affidavit, where they conveniently didn't use the information first for the first warrant. Now they are claiming that it was in plain sight. He was on Instagram and we saw his handle. I'm not an Instagram user. I have no idea, but I hope that this attorney has something to back it up with, that from you as a user, when you are doing the Instagram, you can't see the handle. So it's impossible for these cops or officers or whatever to actually have obtained that information just by looking at the screen.
I do want to make sure it says, if you look at the state's exhibit number 1, it talks about on page 1, 2, 3, 4, 5, page 5, and which was like 1, 2, 3, 4 and 5, the paragraphs. It talks about, we were made of an account that Big Chris had been following. This account is shortness_nest for life. Now, why is that germane? In order to know who was following someone, you actually have to go into the Instagram account, okay, and actually look and find out who the person's followers are. And that's still very similar to this situation. And that was done under that first warrant. On that first warrant, that showed that these followers, and that follower being Corin Gates, short_nest for life. All that information was obtained under the first warrant that was issued. And that first warrant, at that point, that was conceded by the state, was void. So they used that information that was obtained in that first warrant in order to secure and provide information under the second warrant. And so as a result, Your Honor, that's why my motion regarding the fruit of the poisonous tree, because that first warrant was invalid, and the information they pulled, extracted regarding Mr. Eppinger's account had been used to secure this second warrant.
Okay, but let me just distinguish. Okay,
Yes.
Thurston's different from your case, because in Thurston, I want to say the 10th of November of 2020, the police executed a search warrant for Thurston's residence. That warrant authorized the seizure of certain items, including digital devices such as smartphones, but it did not authorize a search of the content of those phones or those devices. So during the execution of the warrant, a cell phone was taken from Thurston's person, later given to a detective who was asked to extract digital data from the phone after being told that it had been seized pursuant to a search warrant. So a little different than your situation right here, wouldn't you say?
It may be somewhat different. However, the same premises still apply. They use that information, okay, that was illegally
But you
downloaded.
got to look at how they got it to begin with, okay?
I understand that, Your Honor.
Okay, and that's different. Your particular information got partially by just observation in the courtroom, which you have no expectation of privacy in.
Well, I beg to differ that you don't have an expectation, and I will address
We're
that.
not talking about attorney-client privilege.
Okay.
We're not talking about any of the materials. But if you're going beyond the courts, because I only authorized them to look at discovery and authorize them to use communications tools on their particular devices. Nowhere in the discussions I had with any attorneys that were involved in this case did I permit that.
Correct.
So if you're just, and there are security measures in this courtroom. So, so when I say you don't have a reasonable expectation of privacy, I want to clarify that in terms of, I'm not talking about attorney-client privilege. I'm not talking about, documents that attorneys are looking at with their clients or conversations. So I want to make that very distinguishing here. Okay.
Okay.
All right.
I understand, Your Honor. So what I'm going to move on to my next point of contention in this matter is that whether this court qualifies as a place of incarceration. The statute, and
Why is that important for your analysis in this case?
well, because Your Honor, I think it goes to the totality of the actual statute itself, and basically
Okay, so lawyer now left that issue. It seems like he moved past it. I do understand that the premise is a bit different, that they had a legal warrant in the case in Thurston, but they only had to obtain the digital devices, not to look through them. They did so anyway, and by that they obtained the next warrant. But for me, the step 2 and 3 here, they obtained information without a legal warrant. That is the same. They used that information to get the second warrant. That's the same. So I'm not sure. This might be a Georgia issue. And yeah, for me, it's similar enough. But apparently the judge doesn't think so. And the judge is the one that makes the rulings. So now we are going up against another thing about wrongfully incarcerated.
this court qualifies as a place of incarceration. The statute, and
Why is that important for your analysis in this case?
well, because Your Honor, I think it goes to the totality of the actual statute itself, and basically the specificity of how the statute was written in
We're
regard.
talking about which statute, sir?
I'm sorry, OCGA 42-5-18. And
Okay, do you have any issue that,
Okay, this is a bit over my area too. The case the defense attorney cited states that information can be obtained in the second warrant only if the facts used to get the second warrant was obtained separately from the info gathered from the unlawful first. But let's have him here and explain himself. Hi, Dave.
All right, I was trying to do it in chat. So what they're trying to say. So there's a theory of the poisonous tree. Hopefully, you guys can hear me okay. I don't have any headphones or anything. When information is gathered unlawfully in violation of the Fourth Amendment or any of the amendments, that information, those facts cannot be admitted in evidence. That's the idea. That's the protection that we have with the Fourth Amendment. So the question then is well, if they discovered it later, could they use it then? And the courts have said, well, if it was discovered independently from the unlawful violation of your rights, then they can use it. So the question is were the facts that they used to get the Second Amendment or the second warrant, were those facts elicited from the first, which was unlawful?
Yeah.
So that's the issue. Sorry, lawnmower.
No worries. Yeah, and as I could understand from the defense attorney is that when you are watching Instagram, your handle isn't showing. I don't use Instagram. I have no idea. But that he should at least be able to show via a screenshot of his own Instagram. See here, Judge, you can't see the handle. They have to have obtained this in another mean than just looking at the screen. But it seems like he dropped the issue, which is a bit... David's gone. Yeah, but let's see what we can hear about this unlawful incarceration. Well, not unlawful, but that he believes that this court does not have the authority to incarcerate his client.
What's your issue on that particular?
okay, so
You have
particularly,
a couple different definitions you're trying to.
I do. Yes, Your Honor.
Okay.
So I want to address that. It talks about it in subsection 2, talk about place of incarceration. It talks about any prison, probation, detention center, jail, institution, including any state, federal, local, or privately operated facility used for the purpose of incarcerating criminals or detainees. This does not qualify in the statute because it would have been very, very well within the plain meaning. It had the intent of the legislators was to include courtrooms. It would have been noted. That was not.
What is he trying to say?
So thus, Your Honor,
He's trying to say he can't detain him in the courtroom because it's not a place of incarceration. That doesn't make sense. The court can take actions to restrain individuals inside the courtroom. I don't. It's just weird. I don't know if this argument is. I have no idea where he's going with this. This makes no sense.
if it was claimed that he used if it is related to the laptop, that in order to no.
I don't know. I guess maybe we'll hear more of his argument. I don't know yet.
It sounds weird because in the courtroom it's up to the judge, even though so it should be under a different law what a judge can do in his courtroom.
Yeah, I would imagine. I mean, we have laws that say what the judge can and cannot. I mean, a good example of that, look at the Brooks case, right? Look at the Darrell Brooks case and what the judge authority had, whether she exercised it or not properly, but she had all kinds of authority like that, right? So,
yeah, unless they just came in and swooped him off his chair during, without a court order. I don't know, but hopefully we will find out.
It's our position that this does not qualify as a place of incarceration.
Okay, but depending upon your status, it would not be if you are still if you haven't been granted bond, and would you still be an inmate, and wouldn't you still be subject to this definition?
Well, Your Honor, in this situation here,
the state claims that they obtained the information, the Instagram handle and his followers, or who he was followed, by observing the laptop in plain sight. That's their argument, the state.
So in plain sight is discoverable if it's in plain sight. That's an exception to the rule. You don't need a warrant if something's in plain sight. So the question really is was it?
Yeah. But that is up to the defense attorney to show to the judge what is in this affidavit can't be true, because this is how Instagram looks when you yourself are logged in. Yeah, it's weird, but it seems like
for the record, the case that he cited and the one that I put in the link, it involves obtaining a warrant for a cell phone after they already received the information from the cell phone, and then used that to justify the first warrant, which was held unlawful. And then they used the additional information that they got from the cell phone as factual basis for the second warrant. And that's what that case was dealing with. And they said, no, if you got it independently, fine, but you didn't get it independently. And so that's what he was trying to say happened here. And I think it's somewhat analogous if they use the information from the laptop to then obtain additional warrants, right?
Yeah, but they claim, the state, that they didn't. They claim the second warrant is based on pure observation of the laptop.
And I don't know enough to comment on that. But
yeah, but according to the defense attorney in the beginning, his claim was that what was it? That the first warrant, who was deemed unlawful, they said they had downloaded something. He doesn't know what, because that was just more. I don't know if he has it written or if it was commented on that they had downloaded something, but then they had to give the laptop back, and then they used in the second warrant and said, by observation we saw his Instagram handle and his who he followed. And the defense attorney says that you can't see that in plain sight.
That's a very interesting argument. I'm wondering what the judge is going to do with that. I'm surprised the defense counsel abandoned it so quickly and went on to this, which I feel like is a nothing motion. But all right, well, we'll go. We'll see.
And Unicorn 11, not just by looking at his Instagram, they claimed they saw him logged in on his Instagram, and then they saw his handle and who he was following, which the defense attorney says you can't see that.
Here, Mr. Johnson is the one that's being alleged to have committed the violation. And so he was never in custody.
Okay, I would agree with you on that. Okay.
Oh,
Okay. So,
But look under that statute, paragraph B. It shall be unlawful for any person to obtain, procure, for, or give to an inmate, and the inmate would be his client, right? Or potentially his client. A gun, pistol, or other weapon, liquor, amphetamines, drugs, I'm just paraphrasing, okay? Any telecommunications device, our computer would probably be one of those. Wouldn't you agree?
that's correct.
Okay, all right. So why wouldn't B be applicable in this case? A is not really applicable to Mr. Johnson. You're absolutely right. But
the defense attorney is this defense attorney is representing the defense attorney who gave the electronic device to the defendant. Oh, this is that one. I haven't reached that far in my trying to get caught up.
That's interesting.
Yeah,
there's so much shenanigans with attorneys and stuff in this case.
Yeah, it's amazing what a cluster.
I see why the argument's being made now. So if the argument is that a courtroom is not a detention facility, then an attorney who's in a courtroom cannot be considered an inmate for the purposes of like those sort of orders, right? Those bond orders or whatever it might be. Okay, so this might have a little bit more merit. I thought he was talking about the defendant that would be in custody, right? He's talking about the defense counsel.
Yeah.
Okay.
Oh, what a cluster F.
B is.
Your Honor, B is applicable but that laptop was given under the authority of the court. It wasn't given
For the limited purpose of reviewing discovery, not communicating with other people and making Instagram or other posts or Facebook or any other things that weren't specifically designed for the review of discovery for this case, because the lawyers.
But is that the defense lawyer's fault? I mean, how can that be? Now, does he have to observe his client? Yes. But being thrown in custody for it, that's a bit over the top. Because, okay, now these two things are related in a circular kind of way. According to the judge, the only thing they could watch on the laptop was discovery, court papers, stuff like that. His client chose to go on to Instagram, which is a stupid move. They saw it and obtained court warrant, and then somehow the defense lawyer got in trouble.
Yeah, I don't know all the facts of the allegation, so that's maybe why I'm a little confused. Yeah. Is it that the defense counsel gave his client a laptop to work with to use for discovery purposes, and then he ended up making Instagram posts instead of looking at the discovery? Is that what happened? I don't know.
Probably.
Okay, so that might be what happened. And Adam 87, you are correct if you are talking to my in-laws who live in Sweden, but I don't know otherwise.
Yeah. But it is gangs killing gangs. It doesn't affect the rest of the population, really.
Here asked me to do that because of the challenges that they had. So that is way beyond the perimeter that the court put out for, for communication or for review of discovery.
Yeah, Honor, I completely understand. I totally agree with you. But in this matter, it says they are actually saying that Attorney Johnson somehow enabled, basically conspired with, participated in this search on this Instagram posting or Mr. Epinger's Instagram.
I don't think they're saying he participated in the search, but they are intimating that his, however it is they did in this particular warrant, that his not, that he basically allowed his client to utilize these other communication tools outside the parameters of what the court authorized. That's what they're alleging. And I think that they're alleging that that he was complicit in the sense that he didn't prevent his client from doing that based upon the conversations that were had or that the affiant made earlier in the warrant.
Your Honor, I believe in this. Obviously, this is a what we call is a specific intent situation. And if you're stating that basically he unlawfully allowed Mr. Eppinger, because we already got to the point that he had possession of it, which is okay. All right, that's uncontroverted. Mr. Eppinger was allowed to possess the laptop. Now, the question goes back to him once again. Is the distinction is possession versus use, okay? And there is nothing in this statute that talks about use of any telecommunication device. It only talks about possession. It's very clear in here about what the legislative intent was about this OCGA 42-5-18, that it was specific when it talks about intent throughout our.
Yeah, but here's the thing. I don't have any issue with what you're saying about Mr. Johnson providing this particular device to Mr. Eppinger for review of discovery. That's fine. That's lawful. Right. That's lawful. And that won't violate 42-5-8. The violation that the state is alleging is when you let an inmate, or detainee, which Eppinger would be, as the lawyer, you let him utilize the device to communicate and utilize other programs like Instagram or other things that would not be within the court's purview. So by that, he's utilizing it for unlawful purposes. And that's what the state is alleging in the warrant by allegedly Mr. Johnson's behavior and Mr. Eppinger's behavior.
Oh, yes, Your Honor, I understand that. But clearly here on the face of this statute, it does not talk about the statute that they're using to support the allegation or substantiate allegations against Mr. Johnson. It does not talk about use. It talks about possession only. Okay. And I understand Your Honor's position. There was you issued a court order which allowed for.
Yeah, well, then he would never be able to use it in my courtroom for any lawful purposes if that was the.
But
okay, so I mean, if you can't have it both ways, I can't let you kind of like, hey, you can use it for one thing, but you can't use it for another thing. And if you use it for that, well, then you violated the statute.
But that's what you're saying, because he was using the computer. I mean, there's no dispute. They said he wasn't using the computer.
Yeah, improperly for unlawful purposes. And I think that because it's to Mr. Delphine's argument, there are times where inmates or detainees or whoever else are permitted to utilize things that would otherwise be considered contraband. And they can use them for, if the same person, like you said, is cutting potatoes in the commissary, that wouldn't be a violation. If they're using a sling blade or a chainsaw to cut grass or trees outside, that's okay too. But if they take that same instrumentality and and secrete it away and use it for another purpose, well, then that would violate the statute. You agree?
Because but at that point in time,
I'm a bit, but this is the defendant who did it. How does that affect his attorney just by, darn it, what are you doing? And not stop?
I mean, if you are facilitating somebody committing a crime, okay, so let's take it out of the courtroom. Let's say this defendant uses his attorney to figure out how to pull off the perfect bank job. And this attorney knows it and facilitates it and says, hey, if you go here, this guard isn't working or whatever. It's still unlawful, right? And so what we're trying to figure out is whether or not this attorney facilitated a criminal act by directly violating the court's order. If the court's order says, don't do this, and the attorney does that, then he's in contempt of court. It could be criminal contempt.
Yeah.
And so that's the issue here, is whether or not he facilitated that.
Yeah. But it's also a question, when did it happen? Under what circumstances did it happen? Was the lawyer looking away and shuffling papers? Was he up on the stand making argument? Or was he actively looking and not doing anything about it?
And look at all the security cameras. I mean, you can see the screen with it all. Presumably this was caught on video, right? So either the defense attorney knew what was happening or he didn't. And I feel like that's going to be fairly apparent through the security cameras in the courtroom.
Okay,
Unless it didn't happen in the courtroom. I don't know. Maybe it happened in a holding cell. I don't know. I shouldn't say that. I don't know.
they have, I mean, of course I don't agree with, because there's no case law out here on it. That's the first thing. There's no case law to make that determination.
But by analogy, wouldn't that be the same argument?
No.
Well, we're going to disagree on that one, okay? Because inmates are often put on work details and other things.
Yes.
And this statute would apply if they went ahead and utilized that particular instrumentality for an improper purpose.
Okay. So, Your Honor, I respectfully disagree.
Oh, okay, and that's okay. You're entitled to.
Okay.
We'll still be friends. It's all right.
All right. Then also, Your Honor, pursuant to my arguments regarding that there's a difference between possession and use, and that's not been enunciated. And I take a strict constructionist view on that statute. That statute does not clearly talks about use. I understand what Your Honor says. However, in our statutes, most that are written by legislators, they both address, a lot of times they address both possession and use. This was not addressed in this particular statute. Okay. Now, the next thing is, Your Honor, that
Hey, Farrell.
now also the information that Mr. Johnson has somehow
I don't know you.
had allowed Mr. Eppinger, the defendant in this case, to, or basically allowed or conspired or aided or abetted. That has not been shown through any testimony. Okay, that's the most germane part. Second part is that it was never indicated in this search warrant how Mr. Johnson, who was actually picking a jury at this time, paying attention to what was going on in the jury room, knew or aided Mr. Eppinger in this search on Instagram. There's nothing in that search warrant. It talks about the times that they approached him and told him that the gentleman was using, which my understanding that Mr. Johnson had admonished the defendant, but we're talking about picking a jury, paying attention since we're talking about January of 2023, January 4th is jury selection had begun, and the voluminous amounts of jurors, and paying attention to what their information is being enunciated or elicited from them. His focus was on jury selection. So thus, he's not paying attention or has no knowledge that Mr. Eppinger was doing anything other than what the court had initially allowed them to do, which was possess the computer and look at discovery. There's nothing in that warrant that says that. Nothing in that warrant that says that. It never said that Mr. Johnson had given his Instagram account in order for him to use. None of that. There's nothing to say Mr. Johnson had knowledge, knew of it regarding the actions of the defendant. Now, if the defendant solely was in this warrant without Mr. Johnson, yes, I understand. But that's not what they accuse Mr. Johnson or participating in this. And not one time was this any of these alleged violations was brought to the court's attention. There was no admonishment by the court of anything regarding Mr. Eppinger's use, because it was never, according to any of the warrants, it was never presented to the court until this warrant was taken out for Mr. Johnson's computer.
It looks like it says in the affidavit, Mr. Johnson was repeatedly placed on notice of Eppinger's illegal laptop usage. Over the course of the entire trial from January 2023 to June 2023, deputies have repeatedly spoken directly to Mr. Johnson about his client's illegal laptop usage, and on at least one occasion, Mr. Johnson demanded that deputies no longer interfere with his client's violation of the law.
Your Honor,
So I respectfully disagree with you about that.
okay, Your Honor, obviously, these are hearsay statements. I understand you're looking at the four corners of the document, but we're talking about a situation where that the standard of proof is, of course, is probable cause. However, it should have been some type of testimony to initiate that, because that's a very germane point, and that was not, okay? Because you actually are using, or they are aligning Mr. Johnson with some criminal conduct. So, Your Honor, that is not our position. Our position is that Mr. Johnson, at that particular moment, selecting that jury, had no knowledge about what was transpiring with Mr. Eppinger. Even from their warrant, they said that the defendant tried to minimize the Instagram account. So ideally, still, you're minimizing something, which means that Mr. Johnson, who was selected a jury, had no knowledge of what was transpiring. And that is the essence of what the basis is for that warrant for that particular day. The one, they actually took a picture of Mr. Johnson's computer, which he had an expectation of privacy of. They took a picture and video that, my understanding, the use by Mr. Eppinger, haven't been provided with any of the information other than what's on the four corners of that warrant. Now, so he did not knowingly allow any of this to transpire. Also, Your Honor, that we are moving that this warrant should be dismissed is that it talks about the reason for the search warrant is because they want to check the browser history. They want to check the aspects of Mr. Johnson's computer. Now, that in itself will violate the attorney-client privilege, because law enforcement is the one that has to download this information. So basically, them downloading this information from Mr. Johnson's computer, in essence, they're going to be able to see information that they cannot unsee. So as a result of that downloading the information, there's going to be attorney-client privilege information and work product.
If we get to that,
Right.
that's why I have Special Master Ms. Lawrence Hardy here to deal with that issue, but I hadn't gotten to that issue. But that's why I decided to take the more prudent course of action and to proceed as we're doing right now.
Yeah, now they are getting into interesting stuff. If they, through the second warrant, downloaded, because this was the attorney's laptop that they obtained a search warrant for, got it, and now they are trying to undo that search warrant.
Yeah. So this is okay. So the idea is that the defendant has the attorney's laptop. Presumably, it's attorney-client privilege. He has an expectation of privacy. Yet they took pictures of it. That's kind of interesting. Wouldn't it be the first time that we've seen court officers or police trying to interfere with discovery or information on a defense counsel's table?
Yeah.
So I think it should fail at the beginning.
Yeah, because it is the lawyer's laptop. Yes, apparently the defendant watched Instagram and I don't know, posted something. I have no idea, but it's still the lawyer's laptop.
Well, it's the lawyer's laptop, but more importantly, even more importantly than that, it's attorney-client privilege, right?
Yeah, not the Instagram, but that should go via a subpoena, not via search warrant.
Why? But why is the court officer looking at the laptop, the attorney's laptop, during a hearing? Right.
Yeah.
That seems to be honest. The officer must be admitting to breaching the attorney-client privilege, right, and breaching that privacy that exists within those confines, and that's stronger than, hey, I have a right to privacy on my laptop.
Yeah, and I do believe that the judge said earlier that the right to privacy was only for looking at the court documents, discovery, and such, not Instagram. But you still have, as you said, you still have to actively look at the laptop to know that he was looking at something else.
Right. So let's say, for example, I'm in mediation or whatever. I'm doing something with my client. The client and I have a personal conversation that's private. We don't expect anybody to hear on. It's attorney-client privilege, whether I'm talking about discovery issues, whether I'm talking about a piece of evidence, about what a witness is going to say, or what the weather is, or what the Lions did last night during the football game. Whatever it is, it's all attorney-client privilege. So for them to be looking at that laptop in the first place, we have a problem.
Yeah, I agree. Let's see how it goes.
So I need to decide the issue of the warrant to begin with.
Yes, Your Honor.
And then I'll get to that. I'll get to that particular, if necessary. Okay.
Yes, Your Honor.
All right.
Hold on one second, Your Honor.
That's all right.
Yes, Your Honor. Just briefly, I'm going to wrap this up.
Go ahead.
So bottom line, well, a couple of other points, Your Honor, is that I want to make sure, I know we had a banter about the issue regarding the analogy that Mr. Delphont brought about being able to be in possession of contraband sometimes in a incarcerated state. Your Honor, basically our position in that situation is that obviously with his analogy, if a person is allowed to have something that was contraband, in that instance, he was talking about some type of tools.
Well, knife. Let's use a knife. Let's use a knife in the kitchen.
Knife in the kitchen.
Okay. All right.
So it's at that point that person is allowed to have that possession, but what happens is that the use of that knife is probably the issue, because at that point in time they use that knife to commit a crime. Okay. So bottom line is you have a possession, which they're probably not going to charge them with the possession because they were lawfully in possession of it. Then, so therefore it goes on to maybe he or she use that knife, which to precipitate another crime, which in this instance would have been some type of crime of violence. But that when the charge wasn't OCGA 42-5 18 in this as applicable to this situation here. So there is some distinguishing situations from his analogy regarding this case and the analogy that he used to.
Yes, Darcy. Bad act from the first warrant should squash the second warrant altogether. I agree. But it seems like the prosecution is doing a workaround by claiming it was in plain sight, therefore, and we saw the Instagram handle, therefore we can, this warrant is good. But I would still, there's a lot of issues regarding this. First of all, attorney-client privilege. How did they know he was on Instagram without, if they were actively, they have to actively look. And as a court officer, you're not supposed to look at what is on their computer at all. Just as you don't go, let me look at this piece of paper. No, you don't.
Yeah, no, it's the same as eavesdropping on an attorney-client conversation. They shouldn't be looking in the first place.
Yeah.
And if they're looking close enough to be able to identify the Instagram followers, then they're looking pretty damn close.
Yeah. Yeah, this is really strange. But it seems like he's moving on to something else here about they are charging him under the wrong crime. I don't know.
Solidify Mr. Eppinger or the use of the computer. So, but yes, but anyway, Your Honor, I think one of the most pressing things in that is that I do want to make sure we repeat the idea that that second warrant was based upon the facts of the first warrant. And so therefore, Your Honor, that second warrant was invalid. Second of all, in addition to that Fourth Amendment, Mr. Johnson never at one time loses his right or transfers his right to privacy of his computer. That never transfers because the court instructed the defendants to use the computers, and that computer was Mr. Johnson. So there was always an expectation of privacy that Mr. Johnson enjoys in that computer. There was never a transfer of that privacy right. He does not lose interest in that. So
I'm not saying he does. I mean,
okay.
I don't disagree with you at all, sir. I don't.
So basically, our position is, as a result of the first deal, there was a search. That illegal search of that first one is a problem, and we can't speak more about it, but it was a problem. So as a result, that the second warrant that was issued is on its face invalid. Secondly, it's invalid based upon the idea the alleged statute that it says he committed does not talk about use. There is the legislative intent never talks about use, and as a strict construction, it only talks about possession only. And moreover, lastly, is that this matter regarding, of course, we'll talk about. You said you can't get to that point, but it's just the sanctity of the attorney-client privilege that we're talking about in here. This is the pillar of our criminal justice system. And for this warrant to be issued with these allegations regarding Mr. Johnson is baseless and should not be used as a means to obtain information. The state has a lot less intrusive ways of getting the information that they need from regarding the defendant. Okay, they indicated they have the defendant's Instagram account, which they could subpoena. They had the young lady, the deputy, her Instagram account, which they could have subpoenaed. There's a much less intrusive ways of getting this information. And so, Your Honor, based upon these things, we move that this motion to suppress should be granted and or motion to dismiss the warrant should be granted.
All right. Thank you, Mr. Hurt. Appreciate you. All right. Sir, anything further?
Oh, that's that
Very
lawyer.
briefly
He was
respond,
good
Judge.
in the Daubert-hearings.
And Mr. Hurd, there's a note that I think your client was there. I don't want to inadvertently read. Judge, just because Mr. Hurd brought up the Thurston case, I feel compelled at this point to tender State's Exhibit 2, which is the original search warrant that was taken out for I believe the court could probably take judicial notice of it, but as Mr. Hurd's reviewing that, I'd like to submit it to the court. And I'd like to point out that I don't think Thurston is applicable in this case, although I very briefly reviewed it here. The facts are very different, including that the officers in the Thurston case conducted a warrantless search of a cell phone before even obtaining an original search warrant. And then ultimately what the court said was that after they did obtain the search warrant, the state said, we realized we probably messed up. We downloaded the data before we got the search warrant, waited a year and a half, got a second search warrant with exactly the same facts as the first one. And the Court of Appeals disagreed that that was reasonable under the Fourth Amendment. Here, it's a vastly different situation. Here, there was no warrantless search. They took a search warrant out for the laptop. They did conduct a cursory search of the screen as they took the laptop, but did not forensically download it, did not disseminate the contents of it, and within a matter of a week, 8 days, obtained a second search warrant. The second search warrant containing significantly more information than the first one, materially different than the first one. And
How'd they get it? How'd they get it?
I'm sorry?
How did they procure it?
Procure the second search warrant
Yeah,
through a
how'd they
superior
procure
court
the
judge.
information based to give the Superior Court judge that information?
So just based on the affidavit provided by Investigator McCormick.
Can I see the first affidavit, please?
Yeah.
The states one?
I'm sorry.
Original, the one that has been suppressed, or that you agree that was improper.
I'm going to mark this judge as State's Exhibit number 2.
All right. Any objection to states two, sir?
There is none, Your Honor.
Okay, states two is admitted. Just so I can take a look at it for myself.
Certainly, Judge.
Okay, all right.
So Investigator McCormick's affidavit in the second search warrant, the one that was taken out June 8th, articulates very clearly the observations and the things that they observed that led them.
Yeah, I don't buy that at all. That, oh darn it, the first one was illegal. What can we do to obtain a second one? Let's say, considering everything else in this case, I don't really trust affidavits from the cops in this trial.
To take out the search warrant for Mr. Johnson's computer. Mr. Hurd argues that unsupported, that Investigator McCormick must have obtained Mr. Eppinger's Instagram handle from an illegal search, but he's provided no evidence or information to that point. Judge, he doesn't have the burden, but he has just as much as the right to call a witness to articulate that you can't see somebody's Instagram handle on their PC interface of Instagram.
Oh, hell no. This is burden shifting. If you claim in an affidavit we saw the handle, you need to provide that. This is so dirty. This is so dirty.
He could have called a witness to say any of these things. He's making completely unsubstantiated accusations that we must have obtained some information unlawfully, and that's included in this affidavit. But that's not the determination this court has to make. What this court has to make is a determination about whether or not the judge who signed this search warrant had a substantial basis to believe that a probable cause existed to find the items that were being looked for in the place that was being searched. Judge Eaton in this case was the Superior Court judge who signed this. I think based on the four corners of the document, Investigator McCormick's affidavit, that's exactly what it says. It outlines specifically that Mr. Eppinger was using Instagram. And frankly, whether it's his Instagram or somebody else's Instagram, it makes no difference in terms of a violation of 42-518. Whether he's using his own Instagram account or he's using his friend's Instagram account or some spoof account, he's still violating the statute. So whether or not they could see it or not, I mean, certainly that would be ferreted out through testimony, which I didn't provide because you can make this decision on the four corners of the document based on what Investigator McCormick put. But there is no evidence other than a very generalized statement in his motion and unsupported arguments here today that the second search warrant contained anything from the first search warrant. I provided to Mr. Johnson and to the court back on in between June 2nd and June 8th, all of the screenshots that were taken from the laptop that the sheriff's office took. So you can very clearly see if any information was used from that in this affidavit. And there's no allegations of that. And there's no evidence of that, Judge. I will note that as it relates to, there were numerous arguments that Mr. Hurd made about essentially they're not, Mr. Johnson not participating, furthering, assisting or aiding Mr. Eppinger in violating 42-518. Essentially, I term that as I listened to it as a challenge to the probable cause contained in the warrant itself, that there's insufficient probable cause that Mr. Johnson has committed any crime. I disagree. I think that as you have articulated in your conversation with Mr. Hurd, in the affidavit itself, it articulates a half dozen times that the sheriff's office told Mr. Eppinger and Mr. Johnson to stop using Instagram. And in February of 2023, Mr. Johnson specifically stated, stop interfering with my client's use of the laptop, with his use of Instagram to the sheriff's deputies. And that's articulated as well. I think that forms a basis that Mr. Johnson, knew and allowed and facilitated Mr. Eppinger's use of the Instagram account. It further articulates in the affidavit that they sat side by side, that their screens were visible one to the other. And so Mr. Hurd is arguing that, well, Mr. Johnson probably didn't know what he was doing, but they were sitting side by side, and the affidavit articulates that they could clearly see each other's screens. Additionally, at this stage, this is not a trial. We are not in front of a jury with a closing argument to argue that we haven't met our burden beyond a reasonable doubt. The burden is whether or not the judge who signed this, Judge Eaton, could have found a substantial basis to believe that a violation of the law had occurred and that would, evidence of that would be found on Mr. Johnson's laptop. Mr. Hurd repeatedly said, we haven't presented any testimony about Mr. Johnson's aiding or assisting or abetting Mr. Eppinger. But frankly, we're here on a suppression hearing for a warrant. The four corners of the document contain all that's needed in order to prove Mr. Johnson's guilt in that, or at least probable cause for the issuance of the warrant, Judge. And lastly, I just disagree with Mr. Hurd's contention that possessing a knife in the kitchen while cutting potatoes and then stabbing somebody with it would have been, while there would have been charges of aggravated assault potentially or other things, that wouldn't form the basis for possession of contraband by an inmate. I think the statute very clearly, even though they don't use the word use, the application of that statute in common sense and everyday use contemplates that the scope of authorization is material in determining whether an inmate has violated that section. Otherwise, any inmate ever who possesses any item that may be deemed contraband could claim complete immunity from prosecution if they were ever given that at some point. And I just don't think that that's the intent of the statute, Judge. That's all I have.
Yeah, but contraband, I'm not really agreeing that this should be considered a contraband because it is the lawyer's laptop.
Well, not only, I mean, a lawyer's laptop could be contraband, a lawyer's pencil could be contraband, but the point is that it was being used as part of a defense of his case in court. So yeah, I mean, in theory, anything could be contraband, just like the kitchen knife. So I agree with the defense's argument. But it depends on the manner and the mode of usage. So, anyways, I have to jump off for a bit. If you're still going, I'll try to come back.
Okay.
right.
Yeah. Thank you
All right.
for showing up and explaining and stuff like that. And we will try to manage without you.
All right, sounds good. Bye.
Bye. Yeah, let's continue and see if the defense has a reply.
Your Honor, let me brief.
Yeah, sure.
Just a couple of things, Your Honor. First of all, if you look at the State's Exhibit number 2, which was the search warrant itself, the first search warrant, it states, I'm requesting this search warrant in order to go through the laptop's internet browsing data, cookies, and all social media accounts found within the search of the internet history that have an instant messaging, text messaging, or video messaging capabilities. So they, at some point, when they took this laptop, they obtained this information. They obtained this information regarding Mr. Eppinger's account and also the persons that he was communicating with. That was the only way they were able to obtain this information. And the fact that he was following this person, or she was following him, however it was, that was the only way they was able to get that information, was based upon this initial search warrant. Your Honor, particularly that here, there has
What
been.
about the second search warrant? Second search warrant involves Mr. Johnson's activity or alleged activity. So when you say it's a little different, I mean, because that's different than the first search warrant.
Yeah, well, Your Honor, it's different in the fact that they threw Mr. Johnson in this. However, but there's nothing that showed that Mr. Johnson had conspired or did anything to accentuate this Mr. Eppinger's use of it, other than the fact provided to him for him to use it for discovery.
There's a couple of some paragraphs that we went through already.
Yes,
about,
yes,
about that,
yeah.
alleged behavior.
Yes.
So
But finally, Your Honor, I do want to say that in order to issue the search warrant, it has to, one, establish a crime, and it has to be evidence of a crime. And right now, you're talking about they want this browsing history. Everything now is speculation. Okay, what they do have is that they indicated they have Mr. Eppinger in this, but there's no agreement. They have no information that was any type of agreement or any type of thing that Mr. Johnson did to precipitate Mr. Eppinger's use of the Instagram. So those two prongs have to establish a crime, have evidence of a crime, and then right now there is no evidence of a crime. There's only speculation. And so that to me is insufficient for probable cause. And as a result, if it's insufficient for probable cause, the warrant should not be granted.
all right, thank you, sir.
This is just so weird that the defense attorney had to get a lawyer because the court.
I'm going to take about 10 minutes. I'll be right back. I'll be back. We're going to be in recess if you don't mind. Okay, thank you.
Well, at least he has to think about it. I don't know what's going to happen here. But the prosecution is running through hoops to get as much information as they can, which should have been done already, because this RICO trial has been going on for well over a year now. And the trial hasn't even started yet. Let's speed up a bit. See when it comes back. That's more than 10 minutes. There he is. Yeah. It's very interesting to see all this pre-trial stuff that is going on, and I hope we all learn from it. Because once the trial is ongoing, everything will be completely new to a jury. They have no idea about the mischiefs, the prosecutions playing dirty, the experts that aren't experts. Everything will be brand new for them once the trial starts. And it's a 6 to 9 month trial. Yeah, let's see if we have a decision. And while he is shuffling, remember, like, subscribe. If you like it enough, become a member. It's $3 a month. And with that, you get access to the Discord and to members-only content on my channel. Okay. Thank you.
All right, Judge, everybody present and accounted for.
All right, thank you, sir.
Can you please start talking? Come on, Judge. Don't keep us in suspense. Unicorn 11 says, I might be completely off here, but it sounds just like they found out by improper means and then try to find any way to justify. Yes, that is exactly what this sounds like. They are running through hoops and loopholes in order to re-obtain what they want. Come on, George, start talking. We had a 20-minute break. Why aren't you done? Let's see if I can. He's still shuffling.
Between Mr.
Okay, here he's off.
That Mr. Johnson may be in fact a co-conspirator under OCGA 42-5-18. There is not the requirement for the court to go ahead and follow the dictates of 17-5-32C. And in fact, paragraph B under this particular code section 17-5-32 does indicate this code section shall not impair the ability to serve search warrants in cases where the search is directed against an attorney if there's probable cause to suspect such attorney has committed a crime. This code section shall not impair the ability to serve subpoenas on non-suspect attorneys. So in this particular circumstance, the court went ahead and in the abundance of caution, I'm going to went ahead and due to the potentiality that there may be on this computer, a couple things, privileged materials, an attorney work product between Mr. Johnson and Mr. Eppinger, and conversations and others from any of the various co-defendants and their attorneys, those particular conversations with Mr. Johnson as it relates to any particular issues related to the trial of this particular matter. The court went ahead and appointed a special master just for the purposes of following 17-5-32C in the event that
they are already downloaded it, probably.
Did not suppress or did not went ahead and issued, or not issued, but failed to suppress or dismiss the warrant. From listening to the four corners or reading the four corners of the warrant and the arguments of counsel, this court is satisfied that sufficient probable cause does exist as set forth in the record and in the affidavit and
And
application
now
in
they will
front of the
use
Honorable
it to do
Judge
other shenanigans.
Charles Eaton.
I can guarantee it.
The
because
court
they have
finds
been
that
all this
this
time.
information would be sufficient and does allege, in fact, a crime or crimes that may have occurred. For those particular reasons, the court is not going to suppress or dismiss the warrant in this case, and will in fact authorize authorize the search warrant to be executed. Because the court is going to have it executed, and this is a member of the bar, I have Miss Allegra Thomas Hardy, as well as Attorney Lisa Hadar, Hadar, present, who the court has appointed to be the special master in this case. As I understand it, Ms. Lawrence Hardy has been appointed pursuant to the statute that governs special masters. She is a member of the bar.
Yeah, so now prosecution knows that if you make an illegal search, whoopsie, let's work around it and say, oh, we had new information from somewhere else, and try again. And if that doesn't work, try again. Jesus Christ. Yeah, I don't like this at all. I don't like this at all.
Specifically a member of the Board of Governors, and she has been appointed by this court. She will, in fact,
the court order was that the laptop was to be used for looking at discovery and stuff like that only, not for personal use or for Instagram and stuff like that. So, but in this, there seemed to be a bit of empty space between what the court can do and what the law says. So here they might, as Unicorn says, setting a precedent. Now, they can't set a precedent at this stage. Now, the law, they can appeal this decision, and hopefully they will. Because as I see it, this is just the prosecution jumping through hoops to get information allowed that they probably already have. Because I don't trust this prosecution at all.
And I'll let her go ahead and explain what she's going to do at this point in time. But I believe that she is going to go ahead and issue a protocol and discuss with you as counsels what the next steps are. And I'll let her go ahead and do that. And I'll set another date commensurate with what her conversations with you are at this point in time. Madam, go right ahead. Now, you might want to come to the podium, Ms. Lawrence Hardy.
Yeah, exactly. He broke a rule, not a law. Yeah. Well, he broke the court order.
Your Honor, now that this issue has been decided on the search warrant, as a next step, we as special master will issue a protocol for the consideration of all of the lawyers of record. We want to, of course, ensure that all privileged and work product materials are protected until the protocol sets forth details for doing that. But we will, of course, allow the attorneys of record to file objections or to let us know of any concerns. We would ask the court to give attorneys of record 1 week to do that. In the meanwhile, of course, while all of that is resolved, we would leave the laptop under the court's.
And you guy in the background, your lawyer needs to pay attention, because if you are listening to music while in court, while another lawyer is getting his ass handed to him, yeah, that doesn't look good. That's a really bad look.
Custody as it has been safely kept until such time to which we can present the final protocol to the court for the court's approval.
Okay, and at that time, that's when the the laptop would be imaged.
Correct. The laptop will go from where it has been safely stored to the forensic
Bullshit.
expert, and the expert would image it so that that work can be done to sort through any privileged material and any material that is responsive to the search warrant.
Okay. Councils, can you check your calendars, in particular, Mr. Hurd and Mr. Delphont and other councils? I'd probably reset it for next Friday, the 18th. For that, to any objections to have been logged and filed by that time. What I'd do at that point is just make sure that all of them have been filed and that we set some time, if necessary, to address those particular any issues that may be held at that point. Sir.
As to the 18th, I am available. In terms of how the process works, I don't know when we'll receive the protocol.
You receive it today?
Today, fantastic. And then the 18th works perfectly. I could, if I have any issues, I can file anything that I need to by the 18th.
Okay, we'll ask our clerk, Ms. Alexander, to once again see what we need to do in order to get you access to Odyssey. Okay. All right, Mr. Hurd.
Yes, Your Honor. Of course, that'll be 7 days from now. Is there any way we can have that continue to that Monday?
I don't have any issue with that, sir.
So on behalf of the state, somebody can be here. I am starting a jury trial with Judge Tracy Mason, a homicide trial on August 21st. And anticipate being unavailable that day, but I can send a representative to handle any business whenever the court wants to set it.
Yeah, what I'd probably do is on that day is to make sure that everyone who's given the opportunity to file an objection.
Oh, did you see that? Defense attorney kicking the chair.
Handle any business whenever the court wants to set it.
Yeah, what I'd probably do is on that day is to make sure that everyone who's given the opportunity to file an objection, file an objection, and for you all to have some conversations with our special master, and if necessary, then we can set a date for a hearing or to air out those particular issues. And so the 21st would be more a status than it is anything else. Because we need to kind of see how to proceed from there. So 21st, probably be, oh, yes, sir.
Good morning, Your Honor. I'll get up to the Sully minutes we have Mr. Dorsey. Will the clients be brought over for that status hearing on the 21st?
Absolutely.
I will not be available. Me and Mr. Dorsey will be likely picking the jury in the trial that we have agreed to let us know.
Okay, the rest is just setting times for other things. Yeah, this was interesting. I don't like this at all. As I said earlier, this shows that the prosecution can, okay, that was dismissed. Let's work around it. And this time it was allowed. For me, it was apparent that they already have the information they want. They are just searching for a way to use it in trial. Yeah, this trial has been a cluster F for a very long time, and it will continue to be a cluster F. Let's see here. Let's do there. Okay. That was that. That was a few days ago. But we are still not caught up. We are still at the Daubert-hearings from January. So what we are going to do is just look at, I don't know, half an hour of the Daubert hearing from January. So let's continue to see what kind of expert they will bring forward. Oh, it's a cop. This will be interesting. Yeah, I don't know what the guy with the headphones, but it looked like he was listening to music and not hearing impaired earphones. And GD asked, are they dragging this to bankrupt these attorneys? It appears so. I feel sorry for these attorneys. Where's sound, law and crime? I have sound on, so this is law and C-word. Forking up as usual.
United States.
Jesus Christ. That was loud. Well, I'm guessing that the first couple of minutes is just him describing himself as an excellent and law-abiding cop.
And what?
Sorry?
My final 2 years were at Georgia State.
Yeah.
And what did you major in at Georgia Tech? International business. Okay. I'm going to show you what's been marked as State's Exhibit 17 and has already been provided to defense counsel. But if any of them would like to see it, I'll show it to them again prior to me tendering it. Mr. Evans, are you good? We will change that to State's Exhibit 18, your CV.
You may approach.
Thank you, Judge.
Yeah.
Do you recognize what's been marked as State's Exhibit 18?
Yes, I do.
How do you recognize it?
It's my CV form, my statement of qualifications for everything that I've done with the police department.
Is State's Exhibit 18 a fair and accurate recording of your qualifications? Is it your resume?
Yes.
And is your resume, as it is reflected in State's 18, accurate?
Yes.
Your Honor, the state tenders State's Exhibit 18 as evidence.
Any objection? Hearing none, State's 18 is admitted.
Thank you, Your Honor.
The trial, once it starts, is 6 to 9 months.
Mr. Kilgore, you indicated, you stated that NIBIN stands for the National Integrated Ballistics Network. Did I hear you correctly?
National Integrated Ballistic Information Network.
Oh, God, it's a tool.
Would you tell the court what exactly that is?
Yes. NIBIN is a conglomerate of currently 272 computer systems throughout the United States, Puerto Rico, and the British Virgin Islands. What it does is it takes high definition 3D images of cartridge cases recovered from crime scenes and also from cartridge cases from test-fired firearms that are confiscated by the department. It has a complex algorithm that assigns that cartridge case of.
Hold on a second here. I have something to say about what this officer is claiming here. It's bullshit. It doesn't matter how high definition the so-called 3D imaging is of the cartridge. There is no telling from what gun a shell casing has been fired, unless the absolute best, in my opinion, with shell casing identification bullshit is that it can exclude. But I suspect that this officer will testify to, oh, look at this new computer program that can do it even more reliable. No, it can't. For you who don't know, Ian Runkle has, I believe it's Ian Runkle's test for toolmark guys. And more or less, you have 10 or more bags, 20 bullets or 20 shell casings in each. It could be 1 shell casing, it could be 5 shell casing, It could be 0 shell casing. And if you are a proper expert scientist, as these people claim they are, they should be able to determine if it is 1, 5, or 0, or 3, or 7. And if they don't, it's not a science, because it's not a freaking science. Let's continue.
Value. It then searches the database for any other cartridge cases in the database to see if there's any similarities between the two.
Who maintains that database?
The Bureau of Alcohol, Tobacco, and Firearms.
And is that also known as ATF?
Yes.
Would you please, using State's Exhibit 18, would you please read into the record the other training that you have listed on your resume and the firearms principal duties that you have listed on your resume?
So we receive firearms and firearms-related fired cartridge components from the APD property unit. We enter that evidence onto our Justice Tracks software program. We test fire evidence firearms. We enter those test fires and evidence onto the IBIS system, which IBIS is a subsection of NIBIN. It's the Integrated Ballistic Information System. We then correlate results for potential leads and hits on IBIS. We prepare reports. And I'm capable of in-house training on the NIBIN acquisition system.
And would you turn over and read from your resume the listing of other training that you have in NIBIN? I believe that it is on page 2 of your resume. Am I correct?
Yes.
Okay. Would you read your other training?
Yes. I'm a graduate of the Smith & Wesson Automatic Pistol Course. Graduate of the Forensic Technology Incorporated Integrated Ballistics Identification System Data Acquisition Course. I'm graduate of the Forensic Firearm and Tool Mark ID course. Graduate of the Sig Sauer Automatic Pistol Course. Graduate of the Colt M16 Series Armorers Course. Graduate of the Sturm Ruger Automatic Pistol, Revolver, and Rifle Course. Graduate of the Smith & Wesson M&P Pistol Course. Graduate of Advanced Firearms Firearm Tool Mark ID Shooting Reconstruction Course. Attended and graduated for the Glock Automatic Pistol Course again. Attended the Advanced Armament Silencer Shoot and Seminar, 2008. Attended the Advanced Armament Silencer Shoot and Seminar, 2009. Attended the Manufacturer's Annual SHOT Show, January 2010. Graduate of the Smith & Wesson M&P Pistol Rifle Course. Attended the BATF NIBIN Correlation School. Attended the Forensic Ammunition Service Ammunition class taught by George Cass. Attended the Forensic Firearm and Tool Mark Identification course taught by Don Micco. Attended the Basic Metallic Cartridges and Shotgun Reloading class taught by Tyler Black. Graduate of the Glock Automatic Pistol course. Attended the BATF NIBIN Authorized Trainer School. Completed the IBIS Tracks HD 3D Match Point Brass Tracks and Bullet Tracks e-learning module. Graduate of the Glock Armorers course and C-Glass review of ISO IEC 17025 requirements.
Tell the court, if you will, what is it that the Atlanta Police Department Crime Lab consists of?
Currently, we have the NIBIN units and we have the fingerprint identification unit.
What is it that the NIBIN units specifically do and how are they utilized?
Again, we take cartridge cases from crime scenes and we test firearms that are confiscated. We enter those into the NIBIN database to see if any potential leads come up.
Can anyone off the street come in and access those NIBIN units?
No, it is a lockdown access.
It's still shit science, no matter how inaccessible it is to the public?
By the Bureau of Alcohol, Tobacco, and Firearms. They have to grant you access and password to get onto the system, and they are currently utilizing fingerprint identification to be able to log on also.
Do you have to have any specialized training in order to utilize the NIBIN units?
Yes, you have to have attended the NIBIN acquisition school to be able to access the system.
You talked about acquisition and correlation.
Yes.
Could you please explain to the court what those two terms mean in the context of NIBIN?
Acquisition is when we actually take the photographs of the cartridge cases.
On Rumble, for me to know, I thought using this evidence was going before SCOTUS. Yes, it still hasn't gone before SCOTUS. It is sent to SCOTUS, but they haven't made a ruling or anything. I don't think they even have gone to... They have submitted it. And we are hoping that the SCOTUS will take those cases up.
Correlation is when you review the results of the results that come back once it's been submitted to the database.
How many employees work currently in the Atlanta Police Department Crime Lab that have access to the NIBIN units?
Currently, there are only 5 people that have access to the login system.
What are their positions?
4 are, including myself, NIBIN technicians. The other position is our lab manager.
And what is it that your lab manager does?
She is actually a firearms examiner, so that she's able to review any results that we get.
And distinguish, if you will, for the court, a firearms examiner and a NIBIN technician.
A NIBIN technician, we only enter the stuff on the system. A firearms examiner can confirm whether or not cases that we get as a potential match are actually.
No, they can't. No, they can't, because it's a shit science.
Linked together.
If you, as you put it, only enter stuff on the system, why is it that being a NIBIN technician or accessing NIBIN units requires such training as you described for the court?
Because you have to be able to look at the cartridge cases and know how to put them in and the exact reason you're putting them in order for the correlations to come back correctly.
And what is it that distinguishes you as the lead NIBIN tech from the other NIBIN techs that work within the Atlanta Police Department Crime Lab?
I have more years of experience. The next person under me, the most she's done is she's on her 6th year.
Now, as a NIBIN technician, and specifically the lead NIBIN technician, do your duties entail test firing weapons as they come into the crime lab?
Yes, it does.
Why do you do that?
We test fire the weapons so that we can enter that cartridge case on the NIBIN system to see if it has any potential links with any other crimes.
And explain to the court what you mean when you say cartridge case.
Cartridge case is one of the 4 components of a cartridge. So a cartridge consists of the casing, the primer, the gunpowder, and the bullet or projectile.
And when you speak of a cartridge, are you talking about what ordinary lay people would just call a bullet?
Yes.
An unfired bullet?
Yes.
All right. And does the number of cases that you enter into the NIBIN system at all inform or expand your knowledge in the field that you work?
Yes, it's a constant learning position. So anytime a new firearm comes out, the markings and everything on the casing could be different. So anytime something new comes out, it's always changing. So you're constantly having to keep up to date on new technology.
Why is it that it is important, if it is important, for you to be aware of that type of information?
Because the way the NIBIN system searches, it can search by firing pin impression and type. There are several different types of firing pins out there. You've got elliptical, you've got circular, you've got rectangular. So if you don't put it in correctly, then it will not search the correct database to be able to deliver results.
How many test fires or how many weapons have you test fired during your time as a NIBIN technician?
I've test fired in excess of 7,500 firearms.
How many?
You've been bullshitting for many years. And yeah. I don't like this. I don't like this. But this is nothing new to you who have seen me before. My feelings towards this so-called science, that it's not a valid science, because they only compare and then in their opinion, yes, this is a match. Or they use buzzwords like this is similar to, this is conclusive, not conclusive with, but other buzzwords to say, yes, this is in my opinion. Here's the thing, in science, you don't need an opinion. You just show the math. You just show the evidence. And here's the thing, have you ever seen in the last, not counting CSI and stuff, these people actually showing what they are testifying to? The actual casings, the actual bullets. Look at here. Look how we compared. Look how we spun it around until we found something that matched. Okay, can you now prove that that specific line wasn't on the other side? Because it's 2 round bullets. How do you say that that particular line? Yeah, it's so stupid. It's so freaking stupid.
Shell casings have you had an opportunity to place into NIBIN?
In excess of 21,000.
And have you been designated a trainer of any sort with respect to NIBIN?
Yes, I'm a NIBIN authorized trainer.
What do you have to have qualification-wise in order to be designated a NIBIN authorized trainer?
The ATF has a training course where they bring you in and teach you how to teach other persons to use the system so that they are using the same protocols as everyone else.
During the course of the pendency of and prior to the indictment of the case that you've been called to testify for today, have you scanned casings into the NIBIN system for the Atlanta Police Department?
Yes.
And would you please tell the court how it is that you ensure the accuracy of the results that you gain as a result of those scans?
When we scan those in there, we have to review them when we do the correlations. We also have a second.
Correlation isn't causation, you garbage. You can never correlate science. You need causation. Oh, I hate this. Bullshit science.
Secondary person review those correlations also to see if there's any errors that were made. And then if any.
The person I work with said I was right. Not good enough. Not anywhere near good enough.
Any potential leads are found, a third person will look at those to see if there's any type of mistake.
Nobody is a neutral part. None of them. You just hand over, I matched these 2 bullets. Can you look at and look and see if they are actually matching? No. Jesus Christ. It should be independent research on that. An independent neutral part who will receive the exact same amount you started off with, 50, 100, I don't care. And that person must reach the same result regardless of what you found out. Then you have this starting of an actual scientific approach. But you just bloomp this one, show the next one. Yeah, sure, you were right. Let's show you to a third one that we also work with, that also is trained by the same people we are trained by. Boom. Yeah, sure, it was the same. Oh, I won't stroke out on this.
And have you done that with each piece of evidence that you have placed onto the NIDIN system?
Yes.
Would I, an ordinary layperson, be equipped to walk into the Atlanta Police Department crime lab, even if I'm escorted with someone, and place a shell casing into NIDIN?
No, you would not. You have to have access to the computer, and you have to be trained first.
If you gave me access to the computer and I went up to the system with a piece of evidence in the form of a shell casing and placed it into the system, with you standing there next to me, would I, an ordinary layperson, without your training, background, and experience, be equipped to understand any output or results?
You would not.
Explain to the court what it is exactly that happens when you take a piece of evidence and input it into the NIDIN system.
We put the evidence in. It takes upwards of 7 to 7.5 minutes for it to take all the pictures of the cartridge case. Again, it's high definition 3D imaging. Once it does that, it assigns that cartridge case a numerical value, done so by a complex algorithm. Once you submit it, it then takes and searches that value against any other cartridge case.
That's not an argument in itself that the algorithm is complex. That's not an argument. You can have the world's most complex algorithm and the basis of it is flawed. Then it's still shit. Jesus Christ, I hate this. I hate Toolmark's testimony.
Cases in the system, see if there's any similarities close enough to call it a potential lead.
And this high definition 3D imaging, is it in the form of or conducted or captured by any kind of particular microscopic camera, or is it just a regular?
It's a microscopic camera at 40 power magnification.
How many?
40 power magnification.
And when you say submit,
40 power magnification. "40 times magnifying glass." Let's see here what that is. Yeah. Do you want to see 40 times magnifying, what that looks like in real life? Here he claims, oh, scientific. Because it is sold on Amazon and it looks like this. That is a scientific. I mean, this is so stupid. This is so amazingly stupid. 40 time magnification that's Sherlock Holmes magnifying. I believe those jewelry loops, those are better than 40 times magnification. I mean, this is so immensely stupid. This is so... Breathe. If you haven't noticed, I have certain feelings against bullshit like this.
It then submits
Yes.
the image. What do you mean?
It downloads to the data concentrator where all of the other cartridge cases are stored for it to search.
And what is it that your training allows you or causes you to do that I wouldn't be able to do if I went up and just put a shell casing into the system?
You wouldn't be able to open the system up without having an access code.
That doesn't mean it's good. I mean, I have logins to my stuff. That doesn't mean that I'm an expert in what on Gmail. I mean, just because you have access to it doesn't mean you're an expert on it. That only means that someone stupider than you gave you access to it.
Password to be able to get into the system, and then you would need to learn or know how to create the case.
How to do what?
Create the case, which is putting all the parameters in, the case numbers, the caliber, the firing pin impression shape. You would have to know how to do all that to be able to open the system up to insert the cartridge case.
And is
Oh yeah, I forgot to put it up here. I saw you, that was a while ago. Dun, dun, dun. Where was it? Here. A gentleman who I was speaking to, who now makes swords for the Royal Guard and used to also make ammunition, was saying similar. He actually done tests to show it. Yeah. And I really hope that Ian Runkel's tests, if he can do a stream where, hey, go over here to put money in, because I think between him and Branca, there's at least $2,000 as a price on, can you do this test successfully? So we can get more cash to that test, and defense attorneys across the United States will have to subject it to that test.
Is it the experience and training that you have recited to the court that affords you the knowledge that you have regarding those parameters, the firing pin impression shape, the caliber of the ammunition, which allows you to then enter or input that evidence into that system?
Yes.
I'm an expert in putting things into the system. Jesus Christ. How there are so many homeless people all across the world who would beg to be sitting by a computer and entering shell casings into a system. He's getting paid, I would assume, in excess of $100,000 a year. Yeah.
Is that information that is known to the general public?
Not generally.
And I should say, absent specialized training that you described for the court here.
Correct.
Just one second.
Hold on, it looks like Jingles is trying to get in here.
Your Honor, the state tenders Jennings Kilgore as an expert in NIBIN technology.
All right, does anybody want to voir dire, Mr. Kilgore?
Judge, I'm sorry. I'm going to need a little bit of clarification if I can. He's being intended as an expert in NIBIN technology. I'm not quite sure I know what that means. Is he just the expert in explaining what the system does? I don't know. What does that mean?
Your Honor, Mr. Kilgore has testified as to his training and experience that allows him to speak specifically about the results from NIBIN. I don't want to use the word examination because there is a separate person that does the firearms examinations, but the results of the input into the NIBIN system of leads that are generated and evidence that is input into NIBIN. This is a technology that is background and training specific. The ordinary person on the street wouldn't be able to speak intelligently about what a NIBIN lead is, what it does, what it means. So yes,
All right,
NIBIN technology.
But I haven't heard him
Look how
testify
happy
about
he had like
results that come out of the NIBIN or what, if there's any, if there are any charts, if there are any conclusory, any reports. I haven't heard anything about that. Essentially, it seems as though he's being tended as a witness who can say that this is how the machine works, or this is how you input the information into the machine. It might be a little bit more technical than that, but it doesn't sound as though this is something that requires expert testimony.
Well, the word you just said, technical, Mr. Adams, is the reason why it's a subject matter that would be that the average person wouldn't
Technical
know.
meaning it's a machine. I mean, I can put something into a Canon copier, but I can't tell you how the Canon copier works or explain anything that comes out of it. So it sounds as though he's being tended.
Would you like to lodge an objection?
No, I guess I'd like to voir dire him.
Okay.
Your Honor, prior to Mr. Adams having that opportunity, as I'm happy to yield the floor to him to do, I'd also, in addition to NIBIN technology, tender Jennings Kilgore as an expert in the utilization of the NIBIN system itself. Thank you.
Okay. Utilize the NIBIN technology and its utilization?
Yes, Your Honor.
Okay, all right. Okay, Mr. Adams, go right ahead, sir.
Yes. Mr. Kilgore, did you, were you assigned to do anything, to conduct any studies or analyze any reports or any results of anything in this case?
Yes, well, with the NIBIN system in general, the correlations is where we view the results of the.
correlation is not causation. Jesus Christ.
Cartridge cases that we submit to look for any potential leads.
Okay. And so were there results of submitted cartridge casings that you were tasked with looking at?
Yes.
Okay. Is there a report that has that information that you reviewed?
We do have reports at the lab on the cases that we submit.
Okay. And do you have those reports here with you?
I do not.
Okay. Are you in a position to explain anything that is in those reports, exactly what they say, how they're interpreted?
I would have to look at each one. If it has a NIBIN lead, it would say in there that the two cases, there was a potential lead between the two cases. And when we say potential lead, that means that the NIBIN system, as well as us with our eyesight, has found enough similarities between the two different cartridge cases to warrant further microscopic examination by a firearms examiner.
Okay. You said us and the NIBIN system. So you were actually tasked with looking at something, at a report of some sort, a generated report, and making some sort of conclusion based upon your review of that report?
Yes.
Okay. And where is your report or your conclusions that you arrived at?
Our reports are on our computer system back at the crime lab.
I could bet you money that he only signed off on something the computer printed out. His only expertise is that's it. But log in, push it in, press enter. And he gets paid a lot of freaking money to do it. Oh.
I'm gonna have one moment just to take a look at what's been handed to me by the state. One moment, please.
Yeah, and I am also an expert on the human food processing system because I put something in one end and it comes out something else in the other. That's his expertise.
I will tender that.
This has not been tendered yet, am I correct?
I will tender that as State's Exhibits.
It'd be 19.
Okay, may I approach the witness briefly?
You can, sir.
All right, I'm gonna approach you and show you what's been marked as, well, it's not intended, it's just for purpose of identification. It has a marking on it, as State's Exhibit number 19. Do you recognize what it is I'm showing to you?
Yes, sir.
All right, tell me if you would, without going into the substance of it, what it is generally.
This is a NIBIN report where we have entered cartridge cases onto the system.
Okay, now let me hold on to that a second if you don't mind. So this is a report that's generated based upon information entered into the NIBIN system, is that correct?
Yes.
Are there additional either reports, graphs, readings that go along with this report?
No, that would be a final report.
Okay, this is a final report and this was prepared by yourself, is that correct? Okay. Is there anything else that's generated by the NIBIN system other than this report?
If they're not for just a general report, but if there's a lead, then there's an additional report that we do if there's a NIBIN lead.
Okay. Was there a lead?
Not on that one.
Okay.
Is he going to testify we put shell casings into the system, it generated a report that it had no match? Oh. Jesus Christ. This is so stupid.
I have no additional questions for the witness.
All right, anybody else? Yes, before you were so rudely hijacked by Mr. Adams, but you were closer, so.
Well, in essence, taking the fingerprints off the cartridge, correct?
Yes, sir. It works with the same concept as the APHIS system for fingerprints.
But you're not the one that actually.
Yeah, and that AFI system has some issues that too. Don't you say? Hey, MG Law, MLS, Dave. He compares it to the fingerprint system. Yeah, I have issues with the fingerprint systems as well because comparing different countries, you need to have between 5 and 12, all the way up to 20 points of identifications to be able to say, yes, that is a match for a fingerprint. I don't know about what the US standard is, but I don't think it's 20. I think us here in Sweden use 14 for it to be conclusive. And everything under that is inconclusive and cannot be used in court. Every time I see MG Law, I'm reminded of Nick's Dragon. Oh, you mean this? Oh, Jesus Christ. Yeah, let's continue.
Actually tests whether the cartridge came out of a particular gun or not.
No, sir, I cannot make a determination if a cartridge case definitely came out of the gun.
These are just the preliminary tests.
Correct.
Then you go to the firearms examiner.
Yes, sir. For a final report and confirmation, a firearms examiner would have to microscopically examine it.
Right, and that's done.
Oh, so the basis of the shit science is a guy getting paid over $100,000 a year entering shell casings into a system. Jesus Christ.
By a microscope, not this highly technical machine.
Yes, sir. They use a comparison microscope.
Isn't the fire supposed to come out of the other end? Yes, it is, but this is a Norwegian fire-farting dragon. They got a little bit wrong there, and but it takes everything by surprise. Everybody who's trying to sneak up on him, oh no, dun dun dun.
And they look at it through the scope with their eyesight.
And they look at the same thing, the firing pin, the mark.
Firing pin striations, markings, everything.
Marks on the cartridge when it comes out of the gun.
Yes.
Okay, I don't have anything.
He is promoted
Okay,
to
all
this
right.
position.
Anybody else? Okay, any argument? If there's no argument, I will go ahead and designate Mr. Kilgore as an expert in NIBIN technology and its utilization.
Okay. At least
All right.
it was limited. Only as its utilization. So he's doing the foundations for the shit scientist. Jesus Christ. We are still only at day 4 of the Daubert hearing. There's additional 2 or 3 days. But we have time to once or twice a week go through what's going on in the Young Thug case. Let's see if I'm just going to look ahead and see if the next one is doing something. Oh, the next one is quite short and intense. Let's continue.
Mr. Kilgore, what I'll do at this point in time is, sir, I'm going to temporarily excuse you as a witness. The state and or the defense of the court will call you at a time certain in the future.
Yes, sir.
You're free to go about your usual duties and avocation. Just don't discuss your testimony with anybody except the attorneys in this case, okay?
Yes, sir.
All right, thank you, sir.
Thank you.
Yeah.
And Your Honor, as I represented to the court and to Mr. Adams that I will be tendering State's Exhibit 19, I'd like to tender it.
All right, any objections, States 19? All right, States 19 is admitted.
Thank you, Your Honor.
All right. Do you have Mr. Tanner available?
We do, Judge.
Okay, let's go ahead and call Mr. Tanner, please.
Okay, let's see what Mr. Tanner is going to put in.
Presentation as part of his presentation, would he be able to set that up as a witness stand, or is there a way that he would be able to set that up?
He's your witness.
I just wanted to make sure the court would be amenable to that.
I don't have any issue with that. If he will aid in him giving his testimony to me, that would be fine. And it can be shared digitally on the Zoom system. That'd be fine.
Okay, thank you so much.
Folks, we're just going to recess in place. We'll go ahead and swear him. He come in. I'll just recess in place till he's ready. Mr. Tanner, good afternoon, sir.
Good afternoon.
All right, sir, if you would please approach the witness stand. Once you get there, if you'd be so kind and turn and face Lieutenant Gibson, be sworn as a witness, please.
You swear or affirm that the testimony you give in this court will be the truth, the whole truth, and nothing but the truth, so help you God. I did. You may lower your hand. You may be seated.
Yeah.
For the record, please state your name, spell your first and last, and state your occupation. Please stick to the microphone. I mean, Madam Prosecutor, where is that PowerPoint
I
presentation?
recognize that guy. I've seen that guy before.
Send it to you via email if you'd like.
Well, actually, we have an opportunity to at least take.
I'm just going to recess in place. Why don't you just pause, show it to those that are here that want to see it, and then he can resume. Okay.
Yes, Judge, thank you.
All right.
Sure. I can send it to whoever, to everybody, if that's, okay.
Mr. Tanner, you okay with us sending your presentation
Yes.
to all those concerned here?
Yes, Your Honor.
Okay. Thank you, sir. All right.
Your Honor, if I may ask Mr. Prince to send me
All right. Do you have it or Violetta? Okay. All right. We're just going to recess in place for the technology piece to catch up.
Okay.
Trying to get everybody's email.
Behalf of Mr. Williams, where is that PowerPoint presentation? Other than this report, where is that PowerPoint presentation located in the discovery material?
He brought that today. I can send it to you via email if you'd like.
Well, actually, we have an opportunity.
So they are bringing up this guy who has a PowerPoint presentation that hasn't been sent to the defense yet. That's interesting. As per usual, prosecution is playing dirty.
To at least take.
I'm just going to recess in place. Why don't you just pause, show it to those that are here that want to see it, and then he can resume. Okay.
Yes, Judge, thank you.
All right.
Sure. I can
Yeah,
send it to whoever,
PowerPoint
to
is a
everybody,
difficult new time.
if that's, okay.
Mr. Tanner, you okay with us sending your presentation
Yes.
to all those concerned here?
Yes, Your Honor.
Okay. Thank you, sir. All right.
Your Honor, if I may ask Mr. Prince to send me
All right. Do you have it or Violetta? Okay. All right. We're just going to recess in place for the technology piece to catch up.
Trying to get everybody's email. Everyone should have it, your emails. I can just show it to, and Your Honor, it's assisting to him, but if the court would like, just go ahead. I believe we can.
No, I can recess a minute. Just like
Anyone received it yet?
it's a PowerPoint, probably.
Mr. Sudi, checking in on behalf of Mr. Dorsey, just a small request. I understand there's new stuff coming up, but if we could get it ahead of time, especially because 24/7, 705 allows us to have access to this data that they're basing their testimony on, ideally before the hearing, so we can be prepared. So if there's going to be any other experts, just send it to us ahead of time, and that one we can be ready for it.
Yes, sir.
Adams did state that they had his report at least a week ago. And so we would ask that the court.
Well, his report, but his PowerPoint has some other additional information that they might, I think that their objection is with any expert, with any report they're going to rely upon, it's supposed to be disclosed for insufficient time for them to at least look at it, consult with somebody, think about it. So, and in this particular circumstance, I think that given the fact that part of his foundation would be that he did this particular report inconsistent with practices or other things, it might just be better for me to defer him until that time.
Yes, Your Honor, whatever the court.
Yeah, I mean, Mr. Jimenez, he keeps.
I joined in, but I also have a different objection. I have an objection to PowerPoint being used at all. What this PowerPoint is, my objection is.
Well, you haven't even looked at it.
I've had a chance to look at it.
Wow, you read all that 42 pages in like 10 minutes?
But just from what I've seen.
Oh, from what you've seen, okay, already.
What it does, it is already stating what the court shall determine. It is, they can ask him questions about his training, how he applies his training, where his training comes from. But what this PowerPoint is showing, this is factor one. And I need this because.
Okay, I'm going to, I hear your objection right now. It might be something that, like I said, is a little premature at this point in time. So, I mean, I don't doubt that. And I just have to be able to take and qualify and determine his threshold requirements. And then some of the other things that you maybe have specific objections to might be better suited at that time, as well as when the witness testifies. So, and, you know, I'll invite the state and everyone to take a look at the PowerPoint, and there may be some specific objections to that defense counsel may have that the state might be able to overcome by agreement or otherwise. So I've noted your objection. Anybody else? So I'm going to defer for the time being. So, all right. Mr. Tanner, what we're going to do at this point in time is just defer you to a little bit of time until the trial actually begins. The state will notify you when you need to come, and we'll call you at that point in time. But don't discuss your testimony with anybody except the attorneys in this case, okay?
They took it all the way up to, you're not supposed to be here until trial if your testimony involves conclusions. Huh. Interesting.
Sure. Thank you for your patience.
Is it possible for us to take Mr. Tanner's testimony on Tuesday of next week?
Let's see what we have to.
Yeah. So now they are only scheduling, and then they will be back after, I believe they are taking a lunch break after this. This is a 9-hour hearing. Jesus Christ. All right. I think that is good enough for today. 2.5 hours of young thug trial and prosecution doing shady stuff. Which means if they are doing this pre-trial, you all know what's going to happen when the actual trial starts. Yeah. They aren't, Gigi says they aren't going to check him out. Check out if he's an expert until... Yeah, it seems like they are going to do voir dire closer to trial or later on during this Daubert hearing. We will see. All right. There's nobody streaming right now that I can send you off to. I think Sal is done already. Let's see if... or... No, Sal is still streaming, so I will send you over to Sal for a bit. And hopefully he will keep you going. And remember, yeah, Runkle is in an hour, I know. Do you want me to send you off to Runkle instead? No, you will probably be at Runkle's anyway, so I will give you to Sal so he can get some watch hours. And either way, thank you all for showing up. It's been a pleasure, as always, to be able to rant in front of you. Thank you for putting up with me. And looking at this Daubert hearing, we will do another one later this week. I will also have an update on the Andrew Tate case. And what else do I have? Well, tomorrow is Jodi Day. Jodi took the stand on day 13. We covered a good hour and a half, 2 hours on Saturday. We will do tomorrow another hour and a half of her trying to claim stuff. And yeah, other than that, thank you all again. You all have an excellent evening in the United States. You are probably already asleep in Sweden. And good morning, Australia. All right. Thank you all. Like and subscribe on your way out, and I'll see you later. Bye-bye.